Please be seated. The sitting is open. For reasons duly made known to me, Judge Abraham is unable to sit with us today. The court meets today and will meet in the coming days to hear the oral arguments of the parties on the preliminary objections raised by the respondent in the case concerning application of the International Convention on the Elimination of All Forms of Racial Discrimination, Azerbaijan versus Armenia. This morning, the court will hear the first round of oral arguments of the Republic of Armenia. I recall that since the court included upon the bench no judge of the nationality of either party, each party proceeded to exercise the right conferred upon it by Article 31 of the statute to choose a judge ad hoc to sit in the case. The Republic of Azerbaijan chose Judge Kenneth Keith, and the Republic of Armenia chose Professor Dode, both of whom were duly installed as judges ad hoc on 18 October 2021 during the phase of the present case that was devoted to a request for the indication of provisional measures submitted by Azerbaijan. Following Judge Keith's resignation on 21 April 2023, Azerbaijan chose Judge Koroma, who was duly installed as judge ad hoc on 20 June 2023. I shall now recall the principal steps of the procedure in the present case. On September 23, 2021, Azerbaijan filed in the registry of the court an application instituting proceedings against Armenia concerning alleged violations of the International Convention on the Elimination of All Forms of Racial Discrimination. I shall refer to this convention as CERD. To found the jurisdiction of the court, Azerbaijan invokes Article 36, Paragraph 1 of the Statute of the Court and Article 22 of CERD. Together with its application, Azerbaijan, who submitted a request for the indication of provisional measures referring to Article 41 of the Statute and to Articles 73, 74, and 75 of the Rules of Court. By an order of December 7, 2021, the court, having heard the parties, indicated certain provisional measures. By an order dated 21 January 2022, the court fixed 23 January 2023 and 23 January 2024 as the respective time limits for the filing of a memorial by Azerbaijan and a counter-memorial by Armenia. The memorial was filed within the time limit thus prescribed. On January 4, 2023, Azerbaijan submitted a new request for the indication of provisional measures, referring to Article 41 of the Statute and Articles 73, 74, and 75 of the Rules of the Court. By an order dated February 22, 2023, the Court, having heard the parties, rejected the request for the indication of provisional measures and noted that the provisional measures indicated in its order of December 7, 2021 remained in effect. On April 21, 2023, within the time limit prescribed by Article 79 bis, Paragraph 1 of the Rules of Court, Armenia raised preliminary objections to jurisdiction of the Court and admissibility of the application with respect to certain claims contained therein. Consequently, by an order of 25 April 2023, the Court, noting that by virtue of Article 79 bis, Paragraph 3 of the Rules of the Court, the proceedings of the merits were suspended and taking account of Practice Direction 5 Roman fixed 21 August 2023 as the time limit within which Azerbaijan could present a written statement of its observations and submissions on the preliminary objections raised by Armenia. The written statement was filed within the time limit thus fixed. After ascertaining the views of the parties, the court decided, pursuant to Article 53, paragraph 2 of its rules, that copies of the preliminary objections of Armenia and the written statement of Azerbaijan, and those objections as well as documents annexed thereto, with the exception of annexes 13 and 14 to Armenia's preliminary objections, would be made accessible to the public after the opening of the oral proceedings. I would now like to welcome the delegation of the parties. I note the presence of 2 agents, accompanied by members of their respective delegations. In accordance with the arrangements for the organization of the proceedings which have been decided by the court, the hearings will comprise a first and second round of oral arguments of the parties. The first round of oral argument will begin with the presentation of Armenia today from 10 a.m. to 1 p.m. Tomorrow, Tuesday, 23rd April, Azerbaijan will present its first round of oral argument from 10 a.m. to 1 p.m. The second round of oral argument of Armenia will take place on Wednesday, April 24, from 4:30 to 6 p.m. And Azerbaijan will present its second round of oral argument on Friday, 26, from 10 a.m. to 11:30 a.m. In this first sitting, Armenia may, if required, avail itself of a short extension beyond 1 p.m. in view of the time taken up by my introductory remarks. I shall now give the floor to the agent of Armenia, His Excellency, Mr. Gishe Kirakosyan. You have the floor, Excellency.
Mr. President, Madam Vice President, members of the court, it is an honor to appear before you as the agent of the Republic of Armenia. This is the second week of hearings in the cases brought to the court by Armenia and Azerbaijan. The court undoubtedly has by now understood the key differences between the 2 cases. Azerbaijan is, of course, free to accuse Armenia of whatever it wishes, but what Azerbaijan cannot do is to extend the court's jurisdiction beyond this limit under the CERD. And it is Azerbaijan's attempt to do so that gives rise to Armenia's objections now before the court. As Armenia's counsel will explain today, Armenia's objection to the court jurisdiction, ratione temporis, and the admissibility of Azerbaijan's claims relates to allegations concerning the First Nagorno-Karabakh War and its immediate aftermath, a period of time that falls entirely outside the court's jurisdiction because the CERD did not enter into force between the parties until 15 September 1996. To be clear, the First Nagorno-Karabakh War was an unspeakable tragedy that engulfed the region as the Soviet Union collapsed. After almost a century of divide and rule by the Soviet Union, the peoples of the region sought to exercise their self-determination. The conflict displaced and destroyed the lives of countless innocent Armenians and Azerbaijanis alike. But that is why Armenia, Azerbaijan, and authorities in Nagorno-Karabakh committed in what is known the Bishkek Protocol of 5 May 1994, followed by 12 May 1994 trilateral ceasefire agreement, and which were further confirmed by the Minsk Group to ensure both ceasefire and reciprocal return of refugees. The authorities in Nagorno-Karabakh vigorously observed the ceasefire agreement and would have welcomed the return of refugees. In contrast, Azerbaijan doubled down on its discrimination against ethnic Armenians, refused to permit UN access to the region, and repeatedly violated the ceasefire agreement, including by, in its own president's words, quote, starting the Second Nagorno-Karabakh War. But let me be equally clear. Armenia also vigorously denies that it has ever endorsed racist ideologies, illegally occupied Azerbaijan's territory, or controlled the authorities in Nagorno-Karabakh, notwithstanding Azerbaijan's agents' attempts to last week to suggest otherwise. It will also not surprise the members of the court that Armenia has its own perspective on the origins of the conflict in First Nagorno-Karabakh War. Armenia set out the basic facts of the conflict on pages 42 to 63 of its memorial in the Armenia versus Azerbaijan case. However, Armenia took care to present those facts as what they are, part of the historical context, and not the facts specific to Armenia's application. Nevertheless, there can be no question that Armenia has innumerable grievances against Azerbaijan concerning the period both prior and during the First Nagorno-Karabakh War. It is, of course, well known that during the Soviet era, ethnic Armenians in the Azerbaijan Soviet Socialist Republic endured discrimination in many forms, including restricted social services and economic resources, and suppression of their cultural and linguistic rights. Armenian historical monuments also were allowed to decay or were outright destroyed, either through neglect or deliberate vandalism. As a result of these policies, by 1987, dozens of Armenian towns and villages in Nagorno-Karabakh had simply disappeared. The population of ethnic Armenians in the province of Nakhichevan fell from 50,000 in 1917 to only 3,400 in 1979. Likewise, the ethnic Armenian population of Nagorno-Karabakh had fallen from 94.4% of the overall population in 1921 to 75.9% by 1979. None of this was a coincidence. On the contrary, it was the intended result of Azerbaijan's deliberate strategy to replace the ethnic Armenians population with Azerbaijanis. In President Aliyev's own words, when referring to his father, the former leader of Azerbaijan's Soviet Socialist Republic and president of Azerbaijan, and I quote, "Under great leader Heydar Aliyev, the percentage of Azerbaijani population in Nagorno-Karabakh increased sharply. It doubled to reach 30%. If Heydar Aliyev had not left for Moscow in 1982 and stayed in Azerbaijan, then the Azerbaijani population could have reached 50% within 10 years. End of quote. As his father himself admitted, and I quote, "I tried to increase the number of Azerbaijanis there and reduce the number of Armenians in Nagorno-Karabakh." End of quote. It is in this context of blatant racist hatred, acknowledged by Azerbaijan's contemporaneous and current leadership, that the ethnic Armenians of Nagorno-Karabakh began a peaceful pursuit of their right to self-determination in the late 1980s. But the movement was met with violent ethnic hatred. A series of brutal pogroms of ethnic Armenians were carried out in Sumgait, Baku, and Kirovabad between February 1988 and January 1990. During these pogroms, Azerbaijani mobs killed, raped, maimed, and burned alive hundreds of ethnic Armenians. In Baku alone, Azerbaijani nationalists were allowed by local authorities to roam the streets, committing brutal murders, torture, and rapes, including of little girls in front of their parents. In 1991, Azerbaijani forces carried out Operation Ring, which violently expelled ethnic Armenians from their homes, emptying 20 villages in then Nagorno-Karabakh Autonomous Oblast and adjacent regions with indigenous Armenian population. Operation Ring was in effect aimed at deportation of ethnic Armenian population of Nagorno-Karabakh and adjacent regions, and was carried out with an unprecedented degree of violence. When the Soviet Union officially dissolved full-scale war broke out. Azerbaijan laid siege to Stepanakert in Nagorno-Karabakh, shelling civilians for 6 months. Azerbaijani forces also massacred civilians, took hostages, desecrated cultural sites, and ethnically cleansed Azerbaijan of hundreds of thousands of ethnic Armenians. As a result of the violent pogroms in the First Nagorno-Karabakh War, approximately 48,000 ethnic Armenians were displaced to Armenia from Nagorno-Karabakh. Approximately 360,000 were displaced to Armenia from the rest of Azerbaijan, and tens of thousands were internally displaced from Armenia's border regions to other parts of Armenia. But, Mr. President, members of the court, Armenia acknowledges that the facts that Azerbaijan did all these things does not bring them within the jurisdiction of the court. As Armenia's esteemed counsel will explain, the court's jurisdiction is confined to the period after the CERT entered into force between the parties in September of 1996. And Armenia has carefully respected the limits of that jurisdiction. Azerbaijan, in contrast, has not. But it cannot be, as Azerbaijan would have it, that the parties to the CERT would have wished to allow those who later acceded to the convention to gain a procedural advantage by penalizing those who earlier acceded to the convention. It cannot be that Armenia, in the midst of First Nagorno-Karabakh War, agreed to immediately subject itself to possible claims by Azerbaijan in the future, while limiting itself to bringing claims concerning whatever period after which Azerbaijan might later unilaterally decide to accede. And it cannot be that Azerbaijan may bring unfounded allegations relating to the period between July 1993 and September 1996, but that Armenia is without remedy for the numerous acts of racial discrimination that Azerbaijan committed during that period itself. Even if the court has jurisdiction over Azerbaijan's claims prior to the entry into force of the CERT between the parties in 1996, Armenia respectfully submits that those claims would still be inadmissible. Azerbaijan cannot be allowed to sit on its alleged grievances under the CERT for nearly 30 years, only to finally pursue them after many witnesses are long gone and the evidence has disappeared. And Azerbaijan particularly cannot be allowed to do this after it unilaterally changed the status quo by attacking Nagorno-Karabakh in 2020, and then expelled its remaining ethnic Armenian population in 2023 in violation of the CERT and the court's orders, thereby further preventing Armenia from marshalling its defense. Armenia's other objections relate to Azerbaijan's claims concerning the environment and landmines, respectively. In contrast to Armenia's claims, to which Azerbaijan objected last week, every one of which was supported by overwhelming evidence of mistreatment of ethnic Armenians on explicitly ethnic grounds, the claims to which Armenia objects are, on their face, incapable of falling within the provisions of the CERT. With respect to landmines, the court has already found on 2 separate occasions, and on the basis of nearly identical body of evidence, that the CERT does not even plausibly impose any obligation on Armenia to take measures to enable Azerbaijan to undertake the mining or to cease and desist from planting landmines. Azerbaijan has offered no new evidence suggesting that these claims are capable of falling under the CERT now. Indeed, landmines and booby traps are inherently indiscriminate and therefore incapable of distinguishing between members of different national or ethnic groups. Moreover, many of the landmines in question were planted by Azerbaijan, And it was Azerbaijan that vehemently obstructed the mining in Nagorno-Karabakh for decades by blacklisting the sole humanitarian demining organization operating in Nagorno-Karabakh, as well as penalizing its activities. And while Azerbaijan is now trying to reformulate its landmine claims in a different way to survive our jurisdictional challenge, the reformulation itself is fatally flawed. Azerbaijan's claims concerning the alleged destruction of the environment likewise fall outside the jurisdiction of the court. Even if alleged environmental harm were in principle capable of constituting racial discrimination in exceptional circumstances, it could not possibly do so here. Armenia could not have engaged in racial discrimination against ethnic Azerbaijanis who, according to Azerbaijan, no longer even lived there in the relevant territories and were not intended to return. Further, as a legal matter, Azerbaijan cannot show that the alleged environmental harm involved differential treatment of human beings, cannot show that the harms it alleges were based on the ethnic or national origin, and cannot show that they had any discriminatory purpose or disparate adverse effect. Mr. President, members of the court, the remainder of Armenia's presentation will proceed as follows. First, Mr. Lawrence Martin will explain why the court lacks jurisdiction ratione temporis with respect to Azerbaijan's claims relating to the First Nagorno-Karabakh War and its pre-15 September 1996 aftermath. Second, Professor Darjan will continue Armenia's submissions on the admissibility of the same claims. Third, Dr. Konstantinos Salonidis will address Armenia's objections to the court's jurisdiction ratione materia over Azerbaijan's claims regarding landmines and booby traps. Fourth, Ms. Alison MacDonald will explain why Azerbaijan's allegations concerning the environment fall outside the cert as well. Finally, Professor Sicilianos will explain why Armenia's preliminary objections have an exclusively preliminary character, thus should be decided at this stage. Mr. President, Madam Vice President, members of the court, thank you for your kind attention. May I ask now that you invite Mr. Martin to the podium.
I thank the agent of Armenia for his statement. I now invite Mr. Lawrence Martin to take the floor. You have the floor, sir.
Mr. President, distinguished members of the court, good morning. It's a privilege to appear before you today on behalf of the Republic of Armenia. This morning, I will address Armenia's first preliminary objection and explain why Azerbaijan's claims relating to the First Nagorno-Karabakh War and its immediate aftermath fall outside the court's jurisdiction, ratione temporis. In short, they do so because they concern alleged acts and omissions occurring before 15 September 1996, the date the CERD entered into force as between the parties. Following me, Professor Darjan will demonstrate why, even if the court finds that it has jurisdiction over such claims, quod non, they would be inadmissible in any event. As our agent just said, the court will by now have understood the key differences between this case and the one brought by Armenia that was the subject of last week's hearings. Faced with Armenia's claims, Azerbaijan has resurrected historic grievances reaching back into the 1980s and early 1990s and attempted to shoehorn them into the court's jurisdiction under the CERD. In its memorial, Azerbaijan was conspicuously silent on the temporal limits of the court's jurisdiction. CERD entered into force for Armenia on 23 July 1993. It entered into force for Azerbaijan, and thus, between the parties, more than 3 years later, on 15 September 1996. Yet, Azerbaijan's memorial did not offer either of these dates, or any other, as the critical date for assessing the court's jurisdiction. It was only after we submitted our preliminary objections that Azerbaijan accepted some temporal limits on the court's jurisdiction. The parties now appear to agree on two basic propositions. First, they agree that claims relating to what Azerbaijan calls, quote, Armenia's pre-23 July 1993 conduct are outside the court's temporal jurisdiction. Azerbaijan has made clear that it does not allege breaches of the convention on the basis of conduct that occurred before that date. It now says that this pre-July 1993 conduct is presented simply as, quote, background and context. Second, and again to use Azerbaijan's phrase, the parties agree that the alleged, quote, breaches occurring entirely after 15 September 1996 are within the court's temporal jurisdiction. The parties appear still to disagree, however, on two other basic propositions. First, what is the critical date for defining the court's jurisdiction under Article 22? Azerbaijan argues that the relevant date is 23 July 1993, when the SURD entered into force for Armenia. We say the critical date is 15 September 1996, the date when the SURD entered into force for Azerbaijan, and therefore the moment from which both states were parties to the convention. Second, assuming the critical date for the court's jurisdiction is indeed 15 September 1996, do Azerbaijan's claims regarding conduct occurring between 1993 and 1996 nevertheless fall within the scope of the court's jurisdiction ratione temporis? Azerbaijan argues that they do, characterizing such conduct as involving breaches of a continuing or composite nature. We disagree. The court's answers to these two basic questions will allow the parties to efficiently argue their cases in the subsequent phase of these proceedings and spare the parties from debating and the court from having to deal with the merits of claims that are outside the court's temporal jurisdiction. It will also provide guidance for any counterclaims that Armenia may advance. Now, let me be clear. Armenia is not asking the court at this stage to ascertain the timing of each putative breach Azerbaijan alleges, nor is it asking the court to decide whether each and every claim falls within its temporal jurisdiction or not. That exercise would be too intertwined with the merits to be decided definitively at this stage. It will be for Azerbaijan to prove in the next phase of the proceedings that each of the breaches it attributes to Armenia actually falls within the temporal jurisdiction of the court. What we are asking for is jurisdictional guidance for the parties' presentation of their claims going forward. With that, Mr. President, I will now explain Armenia's position on the two basic questions in dispute between the parties. First, does Article 22 only afford the court jurisdiction over events that occurred after the SURD's entry into force as between the parties on 15 September 1996? We say the answer is plainly yes. The court, of course, is no stranger to Article 22 of SURD, which you see on the screen now. It carefully circumscribes the jurisdiction of the court to disputes, quote, between two or more state parties with respect to the interpretation or application of the SURD. The plain text of the provision makes clear that for there to be jurisdiction, the dispute must concern the application of SURD as between two or more state parties. It therefore does not apply to acts or facts that preceded SURD's entry into force as between the relevant state parties, as there could be no dispute between two state parties regarding the interpretation or application of the SURD when one of the states is not, in fact, a party to the treaty. Basic principles of non-retroactivity and reciprocity that animate the law of treaties and the law of state responsibility dictate the same conclusion. To state the obvious, Article 22 of the CERD is not a declaration under Article 36(2) of the Court's statute, nor is it a general provision for the settlement of disputes, such as those found in treaties concerning the peaceful resolution of disputes, like the Pact of Bogota. Rather, Article 22 is a compromissory clause designed to address disputes concerning the interpretation and application of the CERD as between two or more states parties to it. Under Article 22, only alleged breaches that occur after the entry into force of the CERD as between two parties are justiciable as between them. Azerbaijan, of course, takes a different view. It invokes Professor Rosin to argue that Armenia confuses the so-called commencement date, the date on which a party is entitled to invoke a title of jurisdiction before the court, with the critical date or exclusion date, the date defining the temporal scope of the court's jurisdiction. For Azerbaijan, these two dates can be different under Article 22, just as they can be under an Article 36(2) declaration, as discussed by Professor Rosin. Azerbaijan relies on the statement in Professor Rosin's treatise that states filing Article 36(2) declarations use a specific, so-called exclusion clause to, quote, determine whether, and if so, to what extent, jurisdiction has been accepted for disputes having to do with the period before the commencement date. Absent such a clause in either of the Article 36(2) declarations invoked in a particular case, jurisdiction would extend to the period of time prior to the entry into force of the title of jurisdiction as between the parties. But Professor Rosin does not, in fact, support Azerbaijan's position as it relates to this case. In the same chapter that Azerbaijan cites, Rosin also explains that, quote, states have generally drafted unilateral and bilateral titles of jurisdiction in a way which avoids this retroactivity in the jurisdiction of the court. This limitation is not commonly found in compromissory clauses of multilateral treaties, but the point is covered by the general non-retroactivity of a treaty, as set out now in Article 28 of the Vienna Convention on the Law of Treaties. In other words, unlike in unilateral declarations filed under Article 36(2), in the context of multilateral conventions like the CERD, the exclusion is implicit. The title of jurisdiction only vests, both substantively and procedurally, upon entry into force as between the parties. Rosin is not alone. As Armenia underscored in its objections, the International Law Commission noted in its commentaries to the draft articles on the law of treaties in relation to what became VCLT Article 28, that, quote, when a jurisdictional clause is attached to the substantive clauses of a treaty as a means of securing their due application, the non-retroactivity principle may operate to limit, ratione temporis, the application of the jurisdictional clause. And in Amatielos, the court's predecessor, applied the same principle to hold that a compromissory clause does not have retroactive effect absent, quote, any special clause or any special object necessitating retroactive interpretation. In its written observations, Azerbaijan has nothing to say in response to any of these authorities. And its own authority, Rosin, does not support its position. Armenia's interpretation of Article 22 also reflects the intention of states when creating dispute resolution mechanisms in multilateral treaties. The court does not need me to remind it that, in the words of the Factory and Charzai case, quote, when considering whether it has jurisdiction or not, the court's aim is always to ascertain whether an intention on the part of the parties exists to confer jurisdiction upon it. As such, the interpretation of a compromissory clause, quote, account must be taken not only of the grammatical and logical meaning of the words, but also and more especially of the function which, in the intention of the contracting parties, is to be attributed to this provision. There is no indication in the travaux that the parties negotiating the CERD intended to create a jurisdictional basis for unknown future parties to invoke its provisions retroactively. Nor is there any evidence that any of the 182 states now party to the CERD ever understood Article 22 to function this way. There are no reservations stating exclusion clauses to Article 22. Nor, for that matter, are there such reservations under any other comparable multilateral treaty. Azerbaijan accepts that no such reservations exist, but argues that this somehow supports a finding that states are content with an unpredictable, non-reciprocal, and retroactive title of jurisdiction that can be invoked decades after the fact by any state in the world. On this view, Article 22 is an open invitation for surprise attacks just like the one Azerbaijan is making here. Dating back as far as 1969, when CERD entered into force for the 27 states that had ratified or acceded to it, such as Brazil, Germany, and India. This cannot be squared with the widespread practice of states including temporal exclusion clauses in Article 36(2) declarations. By our count, at least 41 out of 74 states with Article 36(2) declarations have opted for such an exclusion. Is it really possible that the same states that carefully insulated themselves from retroactive jurisdiction under Article 36(2) happily welcome it under multilateral treaties? Obviously not. The better explanation is that states understand that compromissory clauses in multilateral treaties already incorporate such an exclusion under the law of treaties by operating between parties only in relation to acts or omissions that occurred after the entry into force of the treaty between those parties. Aside from citing to Roseanne, Azerbaijan relies on two main arguments to challenge Armenia's understanding of Article 22. One, that the issue has somehow already been decided by the court, and two, that the erga omnes character of the obligations at stake is sufficient to override any concerns about non-retroactivity and reciprocity. Both arguments are mistaken. First, no conclusive jurisprudence has emerged in the court's case law concerning the application of compromissory clauses in multilateral conventions to events predating the entry into force of the convention as between the parties. The issue has arguably arisen in 4 cases in the past 3 decades. When examined closely, those cases reveal that, contrary to Azerbaijan's assertions, the question before the court is, at best, undecided. Indeed, in 2 of those cases, Georgia via the Russian Federation and Croatia via Serbia, the issue was argued by the parties, but not decided by the court. The cases were dismissed on other grounds. But the fact that the issue continues to be raised and debated by states appearing before the court in recent years dispels Azerbaijan's contention that the question is somehow settled. That leaves just 2 other cases. The first is the Bosnia genocide case, which Azerbaijan cites repeatedly, claiming that, quote, the court heard and dismissed a comparable objection to its jurisdiction ratione temporis. The case is not, in fact, comparable to this one. In its 1996 judgment on preliminary objections, the court devoted just a single paragraph to issues of jurisdiction ratione temporis under the Genocide Convention. For Azerbaijan, this single paragraph establishes a hard and fast rule that compromissory clauses in multilateral treaties can be applied retroactively, so that jurisdiction can be exercised over the conduct of one party, but not the other party during the same period of time. This reading ignores the facts of the case and the legal questions at issue. Serbia, then the Federal Republic of Yugoslavia, and Bosnia both succeeded to the Genocide Convention in the same year, 1992. Although questions were raised as to the exact timing of Bosnia's succession that year, it was undisputed that the convention applied to both parties during the conflict that lasted from 1992 to 1995. This temporal equality was confirmed by the court in its subsequent order on counterclaims, in which it found Serbia's counterclaims admissible because they pertain, quote, to the same period of time as Bosnia's claims. Retroactivity was not the central issue. This is a far cry from the situation at hand. Azerbaijan is attempting to introduce a stark imbalance between the parties, where the court's jurisdiction over events occurring during the interval between 93 and 96 extending only to Armenia, but not Azerbaijan. We think Azerbaijan misreads the Bosnia case. In our view, the court's statement in that case is best read as responding to Serbia's objection to the court's jurisdiction over acts and admissions before Serbia recognized Bosnia in 1995 when the two states signed the Dayton Accords. This can be seen in the court's reference to Serbia's lack of recognition in paragraph 26 of the court's judgment. The second case is the obligation to prosecute or extradite Belgium v. Senegal. There, the court explicitly stated that its jurisdiction encompassed the parties' compliance with the Convention Against Torture as from the date on which the applicant state, Belgium, became a party to the Convention, which was 12 years after its entry into force for Senegal. The court stated that it, quote, considers that Belgium has been entitled, with effect from 25 July 1999, the date when it became a party to the Convention, to request the court to rule on Senegal's compliance with its obligations under Article 7, Paragraph 1. In the present case, the court notes that Belgium invokes Senegal's responsibility for the latter's conduct starting in the year 2000, when a complaint was filed against Mr. Habre in Senegal. As such, Belgium did not, as Azerbaijan asserts, allege a breach occurring prior to the entry into force of the CAT as between the two parties. There was thus no question of retroactive application of a compromissory clause to cover the period between the respective ascensions of two states to a multilateral treaty. Mr. President, members of the court, that brings me to Azerbaijan's second main argument against Armenia's understanding of Article 22. For Azerbaijan, Article 22 cannot be interpreted as incorporating a temporal exclusion for conduct that occurred prior to the entry into force as between the parties because of the erga omnes character of the Convention's obligations. There's a fundamental flaw in this line of reasoning. Azerbaijan is careful to use the phrase erga omnes and assiduously avoid the phrase erga omnes partes. But those are not the same thing. And Azerbaijan has chosen the wrong one for purposes of this case. Erga omnes obligations, of course, are obligations under customary international law that a state owes to the international community as a whole. Erga omnes partes obligations, on the other hand, are conventional obligations owed to all parties to a multilateral treaty. The sources of the obligations are distinct, even if they may overlap substantively, such as when states codify an erga omnes obligation under customary international law by establishing a corresponding erga omnes partes obligation in a human rights treaty. As you can see in the examples on the screen, in cases under human rights treaties, the court has insisted that an applicant's standing be based on the erga omnes partes character of the obligations. In other words, conventional obligations. Whether or not these conventional obligations, erga omnes partes, also exist and even are identical to customary obligations erga omnes is irrelevant. Obviously, the jurisdiction established under Article 22 of the CERD does not include customary international law obligations owed erga omnes not to practice racial discrimination. Article 22 is clearly limited to jurisdiction over the interpretation and application of the Convention as such. Put simply, Article 22 limits the jurisdiction of the court to alleged breaches of obligations under the Convention owed to other parties to the treaty. From 1993 to 1996, Armenia owed its obligations erga omnes partes only to those states that were in fact partes to the CERD during that period of time. Because Azerbaijan was not a party to the convention during that period of time, Armenia did not owe it any such obligations. Between 1993 and 1996, Azerbaijan could neither have invoked Armenia's responsibility under the CERD nor, obviously, had recourse to Article 22 of the convention, just as Azerbaijan itself had no obligations under the CERD. It is only upon entry into force of the CERD as between its two parties that each state begins to owe the other inter partes obligations under the convention. And as between Armenia and Azerbaijan, those inter partes obligations have been owed only since 15 September 1996. This is because Article 22 is a treaty provision for the enforcement of treaty obligations when such obligations exist as a matter of law between the contracting parties. This basic distinction between erga omnes and erga omnes partes obligations is sufficient to disprove Azerbaijan's arguments that the principle of pacta tertius somehow does not apply. Now, to be clear, Azerbaijan accepts that it was bound by the Convention's obligations as from 1993. Armenia also accepts that those obligations were owed erga omnes partes and that its obligations could have been enforced under Article 2 by any other state party also bound by the Convention at that time. But that does not mean that Azerbaijan can come in post hoc and raise issues with Armenia's alleged compliance with obligations that were not owed to Azerbaijan at the time the alleged conduct occurred. Mr. President, distinguished members of the Court, your answer to the first legal question has wide-ranging implications. As we pointed out in our preliminary objections, there is a half-century gap between the entry into force of CERD for its original state parties in 1969 and its newest state party in 2019. Under Azerbaijan's reading of Article 22, a state that only accepted CERD's obligations in 2019 would be free to take any of its original state parties to task for their conduct as far back as the 1970s and even earlier. It is inconceivable that this was the intention of the parties that drafted and then joined the CERD. And for your reference, at tab 2 of your judge's folder, you can find a list of the 182 state parties to CERD and their widely varying dates of ascension to the Convention. The Court's answer to this first question will also not only affect the application of Article 22 of CERD as between its 182 state parties, it will also affect the operation of compromissory clauses in numerous other multilateral treaties in all fields of international law and the standing of states to bring disputes before the Court based on erga omnes partes obligations. Again, Armenia's position is not that accountability under the CERD should be denied. Rather, such accountability must be reciprocal, must not be subject to abuse, and should not reward states that delay their own acceptance of CERD obligations in the Court's jurisdiction. Accordingly, states that wish to enforce obligations ergo omnes partes must themselves have accepted the same obligations at the relevant time. Simply put, and to quote Thirlway, quote, what is sauce for the goose is sauce for the gander. Mr. President, members of the court, I now turn to the second legal question before you. In an attempt to preserve its claims relating to the interval between 1993 and 1996, even when the critical date of 15 September 1996 is accepted, Azerbaijan attempts to reframe its case as one concerning continuing or composite breaches of international law that straddle that date. Azerbaijan's reframing of its case is studiously amorphous. It refers both to continuing and composite breaches, but of course, those are very different things. That said, Azerbaijan's actual focus appears to be on a theory of composite breach, in particular the alleged composite breach consisting of a so-called discriminatory campaign of ethnic cleansing and racial segregation. It now says, quote, Azerbaijan has presented evidence that, in violation of Articles 2, 3, and 5 of CERD, Armenia carried out a long-standing, brutal, and systematic campaign of ethnic cleansing and racial segregation towards Azerbaijanis based on their ethnic or national origin. Armenia's discriminatory campaign constitutes a composite breach comprised of a series of acts and omissions violating CERD that began before and continued after 15 September 1996, throughout the period of Armenia's unlawful occupation, until late 2020, when Azerbaijan liberated its territories and beyond. The idea seems to be that conduct occurring before 1996 can somehow be combined with conduct occurring thereafter to result in a composite breach that only crystallized after 1996. This new reframing of its case is legally misconceived and untenable. It should be rejected in limine at this stage of the proceedings. Azerbaijan devotes just a single paragraph of its written observations to explaining its inchoate theory as to why all its claims concern so-called composite breaches. It asserts simply that, quote, the ILC has identified systematic acts of racial discrimination as an example of composite breach. But as the ILC makes clear, quote, composite acts covered by Article 15 are limited to breaches of obligations which concern some aggregate of conduct and not individual acts as such. In other words, their focus is a series of acts or omissions defined in the aggregate as wrongful. It is therefore insufficient to establish a repetition of the same acts or omissions, such as individual acts of racial discrimination. As the late Judge Crawford explains, quote, a wrongful act may repeat itself. There are distinct acts which succeed each other and are breaches of the same nature. These are simple, repeated acts. These could be a series of violations of the rights of a civil population or of combatants who were refused the status of prisoner of war, etc. It follows that not just any acts of racial discrimination will constitute a composite act that breaches the CERD. This is clear from the way in which the CERD is formulated. Article 5 foresees specific rights that are often breached through discrete acts or omissions constituting immediate breaches. Those simple breaches are distinct from a situation in which, in the words of the ILC, quote, the obligation itself is defined in terms of the cumulative character of the conduct, i.e., where the cumulative conduct constitutes the essence of the wrongful act. Thus, apartheid is different in kind from individual acts of racial discrimination, and genocide is different in kind from individual acts even of ethnically or racially motivated killing. In an attempt to sweep all of its claims into the temporal jurisdiction of the court, Azerbaijan now alleges that all of the impugned conduct before the critical date forms part of a single ethnic cleansing campaign that continued after the First Nagorno-Karabakh War. But this new gambit does not withstand scrutiny. As a matter of law, Azerbaijan has not even tried to articulate the component elements of the delict of ethnic cleansing that constitutes a composite breach of the CERD. Azerbaijan must, as a matter of law, identify the, quote, series of acts or omissions defined in the aggregate as wrongful. It must also indicate at what point in time, and only at that point in time, the aggregation of acts by Armenia crystallized in the alleged breach. Tellingly, it has not done so. It has not done so because its approach cannot be squared with the widely accepted definition of ethnic cleansing stated by the court in Bosnia genocide. There, as you well know, the court stated that ethnic cleansing is the practice, quote, of rendering an area ethnically homogeneous by using force or intimidation to remove persons of given groups from the area. In other words, ethnic cleansing occurs when persons are removed from an area, rendering it ethnically homogeneous. It is once a removal of a population has occurred that the breach of ethnic cleansing is crystallized. And on Azerbaijan's own case, such removal of persons allegedly occurred in the early 1990s and was purportedly completed by 1994, prior to the critical date. Armenia, of course, strongly rejects Azerbaijan's allegations. But even taking its case at face value, they simply could not have been an ethnic cleansing that crystallized after the critical date. Moreover, the limited facts that Azerbaijan alleges occurred after the critical date do not even prima facie amount to elements of any possible composite act of ethnic cleansing stretching back to before 1996. They are, at best, simple breaches of discrete obligations. For example, Azerbaijan points to sporadic instances of alleged violence along the line of contact in 2011, 2015, 2017 as elements of an alleged campaign of ethnic cleansing reaching back to before 1996. Similarly, the purported, quote, erasure of the Azerbaijani character of a mosque in 2019 cannot, on any view, be seen as an element of the same composite act, but rather, at most, is a discrete breach. None of his conduct has anything to do with, quote, rendering an area ethnically homogeneous by using force or intimidation to remove persons of given groups from the area. Put simply, Azerbaijan cannot rely on these other alleged acts of racial discrimination occurring after the critical date to extend the court's jurisdiction over acts of a different character that occurred before the critical date. In other words, the theory of composite breaches, or more correctly, composite acts, put forward by Azerbaijan cannot redefine the jurisdiction ratione temporis of the court in order to include an alleged ethnic cleansing campaign that occurred in the early 1990s. Otherwise, it would be sufficient for a state to allege a pattern or campaign of racial discrimination in order to defeat any temporal constraints on its claims. In fact, if Azerbaijan were right, that would mean that Armenia would be entitled to present counterclaims in this case. Those counterclaims would concern, among other things, the ethnic cleansing of nearly 500,000 ethnic Armenians in the First Nagorno-Karabakh War and its prelude. Indeed, if anything, it is ethnic Armenians who might truly be said to have been the victims of a continuing campaign of ethnic cleansing, as we witnessed in September of last year with the mass expulsion of the remaining population of Nagorno-Karabakh. Mr. President, members of the court, allow me to conclude my submissions on the court's jurisdiction ratione temporis by restating Armenia's two requests for relief. First, Armenia respectfully requests that the court adjudge and declare that the scope of his temporal jurisdiction is limited to Armenia's alleged acts and omissions occurring after the critical date of 15 September 1996, which is when the CERD entered into force as between Armenia and Azerbaijan. Second, Armenia respectfully requests that the court reject Azerbaijan's prima facie untenable theory of a continuing or composite act of ethnic cleansing, and therefore adjudge and declare that any and all of Armenia's conduct occurring before the critical date falls outside the court's jurisdiction. I thank the court for its customarily kind attention, and may I ask, Mr. President, that you kindly call Professor Darjan to the podium.
Thank you, Mr. Martin, for his statement. J'invite à présent Monsieur Professeur Pierre Darjan.
I now invite Mr. Pierre Darjan to take the floor.
Vous avez la parole.
The floor is yours. Thank you, Mr. President. Mr. President, distinguished members of the court, it is always an honor to address you. Now, as Mr. Martin has just demonstrated to you, Azerbaijan's claims relative to the first Nagorno-Karabakh war and its consequences prior to 1996 do not fall under the temporal jurisdiction of the court. Indeed, even if those claims were to fall within the jurisdiction of this court, they would still not be admissible. Now, this is the first matter which I shall address. The first issue is the challenge to temporal jurisdiction. And that is the aspect which I shall address first. Now, this does, of course, not presuppose the order in which the court may prefer to deal with this first preliminary objection to admissibility. Now, Mr. President, there are two aspects in this case, which I believe separately and all the more cumulatively should lead this court to the conclusion that the claims of Azerbaijan regarding the acts of the first Nagorno-Karabakh war and its consequences prior to 1996 should be found inadmissible. First of all, the claims made by Azerbaijan are being made so late that they clearly put Armenia at a disadvantage, in that it could have expected that they would never be framed nor pursued. And furthermore, these claims bring about a very significant procedural inequality between the parties. I shall first address the matter of the late filing of these claims. Now, the first ground for inadmissibility, I believe, is fundamental, and it is related to the excessively late filing of these claims by Azerbaijan. The consequence of the events are the following. The first Nagorno-Karabakh war started at a time when neither of the two parties was bound by the convention, and it ended in May 1994, that is to say, a few months after Armenia acceded to the convention. Azerbaijan, for its part, became party to the convention in September 1996, in other words, a little more than 2 years after the end of the first war. Azerbaijan did not make any claim against Armenia regarding or under the convention until almost a quarter of a century later. In September 2020, Azerbaijan decided to abandon diplomacy and launched a massive attack against Nagorno-Karabakh. The second Nagorno-Karabakh war was brought to an end by the signing of a trilateral statement on the 10th of November 2020. The next day, in other words, on the 11th of November 2020, Armenia notified Azerbaijan of its claims under the convention, claims which largely bear on the tragic events which had just taken place. 1 month after that, on the 8th of December 2020, Azerbaijan rejected the accusations made by Armenia and in turn made claims of its own regarding the first Nagorno-Karabakh war, and this for the first time based on the convention and almost 30 years after the fact. Mr. President, members of the court, next month it will be exactly 30 years since the first Nagorno-Karabakh war ended. 30 years have passed since the events that Azerbaijan is basing its claims upon, and 24 years and 4 months separate the accession of Azerbaijan to the convention and the claims it filed in December 2020 in reaction to those of Armenia. The claim of Azerbaijan relating to these events 30 years ago has been filed excessively late, and therefore it should be found to be inadmissible. In the Nauru case, the court found that even in the absence of any applicable treaty provision, delay on the part of a claimant state may render an application inadmissible. Now, Azerbaijan does not contest this proposition of principle. It's a principle which is well established, and given this, it is irrelevant that the Convention does not set a time limit for presentation of claims. Rather, the matter must be dealt with in line with general international law. These principles are relatively simple. In the absence of a fixed deadline, a claim which is late filed and should be found to be admissible or inadmissible based on the circumstances of the case and in light of the effects of the time which has passed has on equality between the parties. Indeed, it is very important to consider the disadvantage which the respondent suffers in this case owing to the late filing of the claims. Having summarized international jurisprudence on this point, including the findings of the court in the Nauru case, and the late professor, subsequently Judge Crawford, found in his third report that international responsibility of states is such that a case will not be held inadmissible on grounds of delay unless the respondent state has been clearly disadvantaged. He underlined also in the same report to the ILC that the decisive factor is whether the respondent could have reasonably expected that the claim would no longer be pursued. Now, Mr. President, members of the court, there is no doubt that Armenia had a reasonable expectation that Azerbaijan would not make such claims regarding the First War, and this under the convention almost 30 years after the events. Moreover, Armenia is clearly disadvantaged by the fact that Azerbaijan has framed these claims for the first time under the convention regarding this war a quarter of a century after it acceded to the convention. Now, on the first point, given that the convention was not in force between the parties during the first Nagorno-Karabakh war and that Armenia did not accede to the convention until the last months of that conflict, Armenia could have no reasonable expectation that a reclamation, or rather a claim regarding that war, would be made under the convention, and certainly not 26 years after the end of the war. When it acceded to the convention 3 years after Armenia, Azerbaijan remained totally silent on the matter until December 2020, no claim under the convention regarding the First War was made. During that whole period, Armenia could have reasonably expected that no claim under the convention would be made, and what is more, pursued by Azerbaijan regarding the events of the First War, which devastated the parties. I also note that at no point in time during that long period of time did Azerbaijan report violations of the convention in the form of internationally unlawful composite acts, which moreover are alleged to be continuous. However, Azerbaijan contends that Armenia must have known prior to its accession to the convention that such claims would be made, given that it allegedly had objected to Armenia's conduct for decades. Azerbaijan refers in various documents or uses various documents to support this assertion. But none of these documents would give any indication that this was lying in the future. The first of these documents is dated in 1999, and that is to say after Azerbaijan's accession to the convention and 22 years before the application instituting proceedings in the present case. It is the Azerbaijan submissions to the Third Committee, a document which was never addressed to Armenia, and it sets out various claims, some of which dated back to the beginning of the 19th century. Now, the second document dates back to 2016. That's 17 years after the first submission to the committee. It is entitled Illegal Economic and Other Activities in the Occupied Territories of Azerbaijan. This document was transferred to the UN Secretary General and has also not been addressed to Armenia, and it does not in any way constitute a bilateral claim, nor does it announce such a claim. The convention is mentioned only in passing in paragraph 262 of that document, alongside various other treaties which protect human rights. Azerbaijan invokes three letters sent respectively in 1994, 2000 and 2020 to the Security Council. Now, none of these letters actually refers to the convention, nor, once again, to a bilateral dispute with Armenia, either a current or future one, no bilateral dispute under the convention. In the case of the letter of 1994, that would indeed have been most surprising, because at that point in time, Azerbaijan was not yet bound by the convention. It is possible that Azerbaijan understood back then that it would have been futile to claim to avail of the convention in such circumstances, even though Armenia was already party to it at the time. Furthermore, when Azerbaijan finally did accede to the convention 3 years after Armenia, it was well aware of the events which it condemns today. As soon as it acceded to the convention, it could have framed a claim regarding the First War. It did not do so, undoubtedly, because it understood that the First War did not come within the scope of the provisions of the convention between the parties, or that the potential claims under the convention were without basis. It is therefore clear, Mr. President, members of the court, that the documents which have been provided by Azerbaijan did not foreshadow a claim under the convention regarding the First War. Rather the contrary, Armenia had a reasonable expectation that no such claim would be made, given that the convention had been enforced had not been enforced between the parties during the conflict. And Armenia could also reasonably expect that no such claim would be made or pursued 3 decades later. Now, the letter of the 8th of December 2020, in which Azerbaijan rejected Armenia's claims and frames for the first time its own claims under the convention regarding the First War of Nagorno-Karabakh, confirms that never before had that country made claims under the convention. And I would invite the court to read the final paragraph of the second page of that letter, which you will find at tab 3 of your folder. In that letter, Azerbaijan confirms that no claim under the convention had been made during the 3 long decades of mediation under the auspices of the OSCE, despite both parties having acceded to the convention over that period of time. For its part, Armenia did not delay in notifying its claims with respect to Azerbaijan, because it did so immediately after the end of the Second Nagorno-Karabakh War, and that claim dealt with violations which had taken place during that war, a matter brought to this court and which were set out last week. Now, in the first case, Azerbaijan did not make any challenge to admissibility hampered by time constraints. The passage in its letter of the 8th of December 2020, which I've just referred to, confirms that at no point in time since acceding to the convention did Azerbaijan raise claims against Armenia concerning the events which were the subject of the mediation, which had been taking place or had taken place since 1992 under the auspices of the OSCE. And the letter also confirms that that mediation did not indicate or allow Armenia in any way to be able to ascertain that such claims would be made regarding the First War. Quite on the contrary. As Azerbaijan reminded us last week, there was no bilateral contact between the parties during those 30 years. Against this background, Armenia had a firm expectation that Azerbaijan would not raise a dispute under the convention 30 years after the events concerned. Now, the facts of this case are very different to those in the Nauru case, where the applicant immediately notified the respondent of its claims at 4 times between 1969 and 1986, before seizing the court of the matter in 1989, 20 years after the first complaint had been made. In this case, Azerbaijan invoked Armenia's responsibility for the first time under the convention almost 30 years after the events concerned. Now, Azerbaijan says that because it did not have control of the territory during 30 years, it was unable to frame claims before the end of the 2020 war. However, if, as Azerbaijan contends, Armenia is guilty of mass displacement of Azerbaijani inhabitants, or was responsible for such at the beginning of the 1990s, one might wonder what evidence the applicant did not have prior to December 2020. Azerbaijan had every opportunity to collect testimony from its nationals as soon as what it asserts took place. It had access to the type of material which it appended to the application instituting these proceedings long ago, satellite images, for instance. But the fact of the matter is that Azerbaijan's memorial is based on documents which have been available for years, which proves that it could have made its claim before December 2020. Furthermore, the written observations of Azerbaijan in response to the preliminary objections raised by Armenia do not refer to any evidence obtained since the so-called liberation of its territory further to the war of 2020. As Azerbaijan writes, citing the report produced by the Director of Public Prosecutions, which was made after it took control of the territory in 2020, the conclusions of that report confirmed the factual findings made previously by international observers, which had been available for many years. Azerbaijan, therefore, was quite capable of making its claims at a far earlier date, and neither its lack of access to Nagorno-Karabakh nor the absence of diplomatic contacts between the parties had an impact on its ability to do so. Now, Mr. President, I shall turn now to the second aspect, which needs to be taken into account and which I believe should lead the court to conclude that this late filed claim is inadmissible. And that is the fact that Armenia has been clearly, or is clearly, disadvantaged by this extremely late filed claim made by Azerbaijan. More than a generation has passed since the end of the First War. Many witnesses are no longer alive. And that documentary evidence, which has not been lost or destroyed, is patchy. In this regard, it is mistaken to argue that Azerbaijan also suffers from the same disadvantage as that lamented by Armenia. In fact, the sparse evidence which Armenia could have used or could have hoped to use to defend itself is now in the hands of Azerbaijan since the end of the 2020 war, followed in September 2023 by the total takeover of Nagorno-Karabakh, further to the violation of the orders of the court. There is every reason to believe that Azerbaijan will use the evidence that it has thereby been able to illegally obtain in a selective fashion to bolster its claims. It is impossible against this background for legal proceedings to be conducted serenely with equality between the parties and for the court to arrive at a decision which does justice effectively in two events which are so far removed in time. As regarding the late-filed nature of the application, it brings evidentiary difficulties with it, for one and possibly for two of the parties in accomplishment of exact or even approximate justice. And the application, therefore, must be deemed to be inadmissible. However, Azerbaijan argues that the balance of considerations weighs in favour of a finding of admissibility, given the character of the obligations of the Convention, their importance and their purpose. Now, I have three responses in this connection. First of all, it is evidently counterintuitive to invoke the character of the obligations of the Convention, their importance and the purpose, to argue that a claim can be held in abeyance indefinitely and without prejudice to the respondent. Quite on the contrary, given that the Convention is an instrument for protecting fundamental rights, if it is applicable to certain events, it is difficult to understand what would justify a claim being deferred at length. Indeed, the preamble to the Convention refers to the necessity of speedily eliminating all forms of racial discrimination. In fact, the argument made it makes one wonder about the importance which Azerbaijan actually attaches to the fundamental rights of its own citizens. Jura vigilantibus therefore applies all the more here, and the nature of the Convention does not displace these well-established principles regarding inadmissibility of late-filed claims. Secondly, the erga omnis partis nature of the obligations of the Convention do not detract from these principles, given that this feature allowed any state which was a party to the Convention, and since its accession, Armenia, to invoke the responsibility, to invoke its responsibility for violations of the Convention, but no state did so. And that does not excuse the lateness of Azerbaijan, quite the contrary. And then finally, despite the fact that the obligations of the European Convention of Human Rights shared the obligations of the CERD, the court in Strasbourg did not hesitate to consider that the applicant must act expeditiously in making its claims. The court considered as late claims which had been made regarding alleged violations which were continuous in nature, which were filed 6 years after the accession of Armenia to the Convention and 50 years after the events. Mr. President, I conclude on this point. Armenia had a reasonable expectation that the applicant would not make claims regarding the events of the First War and the consequences thereof prior to 1996, and that such claims would not be made or pursued, and indeed Armenia is clearly disadvantaged by these claims. I turn now to the matter of the procedural inequality between the parties. The clear disadvantages resulting for Armenia is exacerbated further based or due to the second ground for inadmissibility in this case. And this is related to the fact that Azerbaijan's claims bring about a considerable procedural inequality between the parties. Indeed, in the scenario that Azerbaijan puts to you, your jurisdiction vis-à-vis Armenia would commence on the 23rd of July 1993 and could concern any events which started or continued after that date. However, your jurisdiction regarding Azerbaijan, in the present case, as in the case which you heard last week, commences 3 years later on the 15th of September 1996, and can only relate to events which took place after that date, whether they be isolated or continuous in time. So the absence of reciprocity and equality between the parties is flagrant, as Mr. Martin explained perfectly, I believe, to you. If the court were to concur with Azerbaijan's arguments with regard to temporal jurisdiction, a procedural inequality would be brought about. Armenia would not be in a position to bring counterclaims on relating to events which took place earlier than the date in which the convention took force for Azerbaijan, in other words, on the 15th of September 1996. And the reason for this is simple. According to Article 80 of the Rules of the Court may entertain a counterclaim only if it comes within the jurisdiction of the court. Now, in the two cases, the jurisdiction of the court vis-à-vis Azerbaijan does not commence until the 15th of September 1996. Mr. President, if we follow Azerbaijan's argument, this case would take place in circumstances where the rules of the court do not have the same meaning for both parties, although the factual complex is the same. And this is detrimental to the equality of the parties and the proper administration of justice. Azerbaijan argues that the equality of the parties should be limited only to the procedural aspect, but in admitting that, and it is something that Armenia contests, we are clearly faced here with a procedural inequality between the parties, which is flagrant and unjust. What Azerbaijan is seeking is to condemn Armenia for events which took place during the First War while being shielded from accusations that Armenia might make in response regarding Azerbaijan's conduct in that same war. This procedural strategy must fall at the admissibility hurdle. The matter of the critical date for jurisdiction, 1993 or 1996, Azerbaijan tells you that this is of little importance and puts forward its theory of continuing and composite international breaches. Mr. Martin has addressed this matter and proven to you that it does not hold water here. Members of the court, is it acceptable in terms of equality between the parties and proper administration of justice that Azerbaijan may present claims regarding the First War, which devastated the parties, whilst Armenia may not? And this despite the fact that Armenia took the obligations of the convention seriously 3 years before the applicant did. What kind of two-speed justice would result? The inequality of a procedural nature is flagrant, and it leads to a historic injustice, to historic justice that only works one way. Members of the court, the various aspects that I've drawn to your attention should necessarily lead you to find Azerbaijan's claim inadmissible. Your Honour, perhaps you would like to order a short break before you call Mr. Salanidis to the bar.
The court will observe a 10-minute break. The sitting is suspended. Please be seated. The sitting is resumed. I now invite Mr. Konstantinos Salonides to address the court. You have the floor, sir.
Mr. President, Madam Vice President, distinguished members of the court, it is an honor to appear before you on behalf of the Republic of Armenia. I will address the court today on Armenia's objection to the court's jurisdiction ratione materie over Azerbaijan's claims concerning the alleged placement of landmines and booby traps in violation of the CERD. I will begin by recalling the reasons why these claims do not fall within the court's jurisdiction ratione materie. I will be brief in that regard because in its written observations, Azerbaijan did not engage with the merits of our arguments. Instead, Azerbaijan attempted to reframe its claims in two distinct ways. First, as purported evidence in support of other claims, and second, as alleged claims of breach of the court's 7 December 2021 non-aggravation order. Neither of these attempts assists Azerbaijan for reasons that I will explain. I now turn to my first point. Professor Darzan recalled the standard governing the court's jurisdiction ratione materie last week when he appeared before you in the Armenia versus Azerbaijan case. The standard is, of course, the same in this case. It has most recently been stated by the court in Ukraine versus Russia genocide case, where the court observed that to determine whether it has jurisdiction ratione materie, it must ascertain whether the facts at issue, if established, are capable of constituting violations of obligations under the treaty. With regard to violations of obligations under the CERD specifically, the court has also noted that racial discrimination under Article 1, Paragraph 1 of the CERD consists of two elements. First, a distinction, exclusion, restriction or preference must be based on one of the prohibited grounds, namely race, color, descent, or national or ethnic origin. Secondly, such a differentiation of treatment must have the purpose or effect of nullifying or impairing the recognition, enjoyment, or exercise on an equal footing of human rights. As we demonstrated in our preliminary objections, even if the acts Azerbaijan alleges in its memorial were established, they would not be capable of constituting racial discrimination under the CERD. This is so for at least two reasons. First, landmines and booby traps are tools of war that are inherently incapable of making a distinction based on national or ethnic origin. Second, any placement of such weapons, to the extent that it was done by Armenia, was done exclusively for defensive purposes. In our preliminary objections, we also recalled that the court has already held twice that at the provisional measure stage that Azerbaijan's allegations do not even plausibly establish racial discrimination. Indeed, after considering virtually the same evidence Azerbaijan cited in its memorial in support of its claims, the court found in its first order on provisional measures, in this case, that Azerbaijan has not placed before the court evidence indicating that Armenians' alleged conduct with respect to landmines has the purpose or effect of nullifying or impairing the recognition, enjoyment, or exercise on an equal footing of rights of persons of Azerbaijani national or ethnic origin. Then, in its second order on provisional measures, the court not only reaffirmed this conclusion, but also extended it to Azerbaijan's allegations related to booby traps. We submit that the court's finding of a lack of plausibility is highly relevant at this jurisdictional stage, when considering whether this exact same conduct is capable of violating the CERD. In its written observations, Azerbaijan chose not to respond to the merits of our arguments. Instead, it contended that Armenia misconstrued the claims set forth in the memorial. Azerbaijan said that its claims about landmines and booby traps are not being put forward as an independent violation of the CERD, but rather as evidence of a tool that Armenia used in its alleged campaign of ethnic cleansing. As such, Azerbaijan says that Armenia's preliminary objection is irrelevant. However, Azerbaijan cannot simply obscure what its claims are truly all about. Rather, the court should objectively determine for itself what Azerbaijan is claiming, to which I now turn. At the outset, it is worth recalling what Azerbaijan said throughout these proceedings about its claim up until its written observations last year. First, in its application instituting these proceedings, Azerbaijan asks, as you can see on your screens, that, I quote, Armenia must take all steps necessary to comply with its obligations under the CERD, including by ceasing and desisting from the laying of landmines on the territory of Azerbaijan. In its memorial, Azerbaijan uses the term landmine no fewer than 73 times. In its memorial, Azerbaijan argues that Armenia violated Articles 2 and 5 of the CERD by, I quote, placing landmines to prevent Azerbaijanis, for reasons of ethnic and national origin, from returning to the liberated territories. In its first request for provisional measures, Azerbaijan alleged that Armenia's, quote, ongoing operations to salt Azerbaijan's territory with more landmines constitute violations which pose an ongoing threat of irreparable harm to rights asserted by Azerbaijan under CERD. At the hearing on its first request for provisional measures, Azerbaijan explicitly argued that these acts, the laying of landmines, constitute acts of racial discrimination as defined in Article 1, Paragraph 1 of CERD, and violate Armenia's obligations and the rights protected under Articles 2 and 5 of CERD. As the court is aware, Azerbaijan sought an order that Armenia, quote, immediately cease and desist from endangering the lives of Azerbaijanis by planting or promoting or facilitating the planting of landmines in Azerbaijan's territory. In its second request for provisional measures, Azerbaijan alleged anew that Armenians' placement of landmines and booby traps, quote, has both the purpose and effect of discriminatorily impairing Azerbaijanis' fundamental rights, including rights to life and security of persons and rights to return home. And at the hearing on its second request on provisional measures, Azerbaijan argued that it, quote, has plausibly shown that Armenia has violated the CERD by planting booby traps and landmines in Azerbaijan's territory that have the effect and the purpose of targeting Azerbaijanis on the basis of ethnic or national origin. Again, Azerbaijan sought from the court an order on Armenia to, quote, immediately cease and desist from any further efforts to plant or to sponsor or support the planting of landmines and booby traps in these areas to which Azerbaijani civilians will return. In its written observations, Azerbaijan changed tack after Armenia raised its preliminary objection. It now purports to abandon all these claims that I've shown you on the screens and asks that the court considers them as mere evidence of other claims under the CERD. It further argues that it is entitled to deference with respect to this framing of its claims. But as the court is well aware, there is no basis for any such deference. The court has repeatedly held that it is for the court itself to determine on an objective basis the subject matter of the dispute between the parties, by isolating the real issue in the case and identifying the object of the applicant's claim. The Court has also repeatedly affirmed that it is entitled to interpret the submissions of the parties, and in fact, it is bound to do so. This is one of the attributes of its judicial functions. In doing so, the Court examines the application as well as the written and oral pleadings of the parties, while giving particular attention to the formulation of the dispute chosen by the applicant. But the Court has specifically held that it will not confine itself to the formulation of the applicant when determining the subject of the dispute. And indeed, it has in the past framed disputes before it in a manner different than how the applicant wished to formulate them. Critically, these statements of principle apply not just to the dispute as a whole, but also to any specific claim or aspect of the dispute. In immunities and criminal proceedings, for example, the Court rejected Equatorial Guinea's framing of one of its claims and proceeded to hold that it did not have jurisdiction ratione materiae to adjudicate its merits. Armenia, therefore, respectfully submits that the Court should assess Azerbaijan's reformulation of claims in its written observations against the same claims as advanced in the memorial, in the application, the memorial, written and oral pleadings of Azerbaijan on its two requests for provisional measures, and as responded to by Armenia's pleadings throughout these proceedings. In our respectful submission, these materials make clear that notwithstanding its representations now, Azerbaijan has claimed that Armenia's alleged use of landmines and booby traps in and of itself violates the CERD. As such, those claims should be rejected for all the reasons I have previously set out. But even if the Court were to accept Azerbaijan's attempt to recharacterize its claims as purported evidence of other claims, it is difficult to see how the same factual allegations could not be good enough to stand as distinct claims of breach of CERD, but be good enough as evidence for other claims of breach of CERD. If there is any reason to see them differently, at this stage, Azerbaijan has not offered it. Judicial propriety and efficiency thus underscore the disposal of Azerbaijan's claims in this regard at the preliminary phase, however one wishes to label them. An applicant cannot invoke, as Azerbaijan does in this case, irrelevant factual allegations in order to establish jurisdiction over its claims. This is why the Court's test for jurisdiction ratione materiae accepts pro tem factual allegations as true. If such claims, however formulated, are not capable of breaching the treaty in question, then there is no need for the Court or the parties to waste time and resources proceeding to their merits. Mr. President, this brings me to my last point. In a last-ditch attempt to salvage its landmines and booby traps claims, Azerbaijan, in its written observations, argues that it also asserts them as an independent breach of the Court's 7 December 2021 Order on Provisional Measures, which requires the parties to refrain from any action which might aggravate or extend the dispute or make it more difficult to resolve. Azerbaijan argues that the source of this obligation, the Court's Provisional Measures Order, so presumably Article 41 of the Court Statute, is separate from the CERD. As such, even if the planting of landmines and booby traps in this case does not fall within the scope of the CERD, Azerbaijan can still claim the same conduct as falling within the scope of the Court's non-aggravation order. We, of course, do not dispute that the Court has jurisdiction to adjudicate a breach of a non-aggravation measure indicated pursuant to Article 41 of the Statute. But unlike the recent Ukraine versus Russia genocide case, for example, here we have a party that seeks to raise as an aggravation the very same alleged conduct that the court rejected in not one, but two orders on provisional measures. This is an important distinction because non-aggravation measures are subordinate to the substantive provisional measures indicated by the court. So Azerbaijan cannot assert a claim for non-aggravation of the dispute by virtue of conduct that did not justify the indication of the substantive measure it twice requested from the court. Such a claim would also be hopeless on the merits. It would be a claim that would necessarily capture only allegations of placement of landmines and booby traps since the date of the court's order, 7 December 2021, and not the signing of the trilateral statement, as Azerbaijan casually asserts in its written observations. It would thus also not be a claim over the alleged use of landmines during the alleged occupation. Armenia strongly denies Azerbaijan's claims of placement of landmines and booby traps since December 2021, and it is no coincidence that Azerbaijan literally provided no evidence, not a single citation or source, in its memorial to support them. But the overarching point, Mr. President, distinguished members of the court, is that the court's jurisdiction over Azerbaijan's claim for landmines and booby traps, asserted as a violation of the non-aggravation order, is not a response to Armenia's preliminary objection. The court can very well uphold Armenia's objection to its jurisdiction over Azerbaijan's claims relating to landmines and booby traps, while simultaneously maintaining its jurisdiction over Azerbaijan's non-aggravation claim. The one does not defeat the other, and Armenia is content to defeat that latter claim on the merits. These reflections complete my presentation, Mr. President, and distinguished members of the court. I thank you for your kind attention and ask you to call Ms. MacDonald to the stand.
I thank Mr. Salonides for his statement. I now invite Ms. Alison MacDonald to take the floor. You have the floor, Madam.
Mr. President, Madam Vice President, members of the court, it's an honour for me to appear before you again on behalf of the Republic of Armenia. I will address you on why Azerbaijan's claims arising out of alleged environmental harm fall outside the court's jurisdiction ratione materiae. The starting point is to look closely at the alleged environmental harms that Azerbaijan seeks to portray as racial discrimination. Azerbaijan complains of a multitude of alleged harms which, it says, have occurred in what it calls the liberated territories. To take them in the order in which they appear in the memorial, Azerbaijan complains of, first, destruction and degradation of forests, second, destruction and degradation of natural monument trees, third, destruction and pillage of water infrastructure, fourth, destruction and degradation of agricultural land and vineyards, fifth, degradation of land and water quality through strip mining activities, and sixth, neglecting and mismanaging the water infrastructure, particularly the Sarsang reservoir, allegedly affecting the Azerbaijani population living downstream. On Azerbaijan's case, all this harm allegedly occurred in the 3 decades in which it describes Armenia as having occupied the territory. Azerbaijan describes Armenia as conducting an ethnic cleansing campaign through the First Nagorno-Karabakh War to create an ethnically pure Armenian settlement in Nagorno-Karabakh. And its case is that virtually no Azerbaijanis remained in that territory after 1994. Time and again in the memorial, we see Azerbaijan referring to the fact that the alleged environmental damage was done during this period of so-called occupation. So, for example, it claims that 8,900 hectares of forest were verified as lost from the then occupied territories during the occupation period. It says, of the registered natural monument trees in the then occupied territories, at least 38 were destroyed during Armenia's occupation. It says the total amount of agricultural land lost from productivity during the occupied period between 1995 and 2015 was 54,544 hectares. And it says that hundreds of kilometres of irrigation canals in the liberated territories were abandoned, unmaintained, and blocked during Armenia's occupation. Now, Armenia would draw your attention to three particular features of this situation. On Azerbaijan's case, firstly, when the alleged racial discrimination took place, Armenia controlled the relevant area, ethnic Armenians lived there, and ethnic Azerbaijanis did not. In other words, the alleged victims of this racially discriminatory environmental harm were not there to experience it. And with respect, that's quite a peculiar scenario for racial discrimination. And secondly, on Azerbaijan's case, ethnic Azerbaijanis were allegedly excluded from the territory by Armenia, not through any discriminatory harm to the environment, but through sheer military force. So, for example, Azerbaijan's memorial speaks of Armenia violating CERD by preventing Azerbaijanis from accessing those territories throughout the entire course of its almost 30-year occupation. And it goes on to allege that the armed forces of Armenia, including its installed regime, sealed off the then occupied territories from the rest of Azerbaijan using physical barriers, military fortifications, landmines and snipers, and deploying threats and intimidation along the line of contact and beyond to reinforce the message that Azerbaijanis could never return to those territories. And this leads to a third element. On Azerbaijan's case, the so-called occupation was no mere temporary state of affairs. On the contrary, according to Azerbaijan, Armenia intended this situation to be permanent. As we just saw on screen, the alleged intention was, quote, that Azerbaijanis could never return to those territories. So, in other words, on Azerbaijan's case, the alleged environmental harm was never intended to be experienced by Azerbaijanis. It was going to be experienced by a permanently settled ethnic Armenian population. So, turning to the law, to survive this jurisdictional phase, Azerbaijan needs to show that the acts and omissions of which it complains are capable of amounting to a distinction, exclusion, restriction, or preference, that is, a differential treatment of human beings. Then it needs to show that any such thing was based on ethnic or national origin. The first requirement here is fundamental. CERD is a human rights instrument. It concerns, as the court has made clear, a differentiation of treatment of which human beings are the object. Azerbaijan's submission is that Armenia violated Articles 2 to 7 of the CERD through, quote, the establishment of an ethnically pure Armenian settlement, notably by, quote, differential destruction and degradation of the natural environment in areas where Azerbaijanis resided prior to Armenia's ethnic cleansing and occupation. But the fact that areas from which Azerbaijanis departed were allegedly the subject of environmental harm does not constitute, Armenia says, any differentiation of treatment of human beings, since on Azerbaijan's own case, no Azerbaijanis were living in those areas when the relevant acts allegedly took place. In short, there could be no differential treatment of ethnic Azerbaijanis as compared with others, since on Azerbaijan's case, there were no ethnic Azerbaijanis present to experience such treatment. So that's the first way in which Azerbaijan's case, by which the absent Azerbaijanis were subjected to discrimination, runs into trouble under the CERD. The next problem is that, assuming for the sake of argument that there was a differentiation of treatment of human beings, it would only be capable of falling under the CERD if Azerbaijan could establish that the acts in question are capable of constituting a distinction, exclusion, restriction or preference based on one of the grounds prohibited by Article 1 of the CERD. Now, Azerbaijan does not suggest that the harms it complains of were based on any of the protected grounds in the sense that that was their stated purpose. We recall that the court indicated in its judgment of January this year in the first Ukraine versus Russia case that a measure whose stated purpose is unrelated to the prohibited grounds contained in Article 1, Paragraph 1, does not constitute, in and of itself, racial discrimination by virtue of the fact that it is applied to a group or to a person of a certain race, colour, descent, or national or ethnic origin. Here, Azerbaijan has not asserted that specific forests were cut, particular mines were exploited, or individual farms were degraded for the stated purpose of discriminating against ethnic Azerbaijanis. Instead, Azerbaijan tries to argue that the purposeful concentration of such development and resulting environmental harms in areas that were predominantly populated by Azerbaijanis prior to occupation, while areas that had been populated by Armenians remained comparatively unharmed, was based on the fact that the populations of these areas were Azerbaijani. Indeed, says Azerbaijan, the only credible inference is that Armenia's conduct was purposely aimed at Azerbaijanis as an ethnic or national group, end of quote, even though Azerbaijan's case is, of course, that Azerbaijanis didn't live in the relevant areas at the time. Now, here it may be useful to pause and consider the proper approach at jurisdiction stage when dealing with such assertions. It is one thing to accept, for this week's purposes, the facts alleged by Azerbaijan, that is, their allegations as to what was done and where. That is a necessary part of the exercise. But it is quite another thing to ask the court to accept completely unsupported characterizations of the purpose behind the acts complained of. As you've seen, Azerbaijan claims that there was a purposeful concentration of environmental harm in areas where ethnic Azerbaijanis previously lived. But it provides no evidence to justify its use of the term purposeful. It simply asks the court to proceed on the basis that decisions about where to mine, for example, or to log, or to rebuild infrastructure, were not based simply on the location of the resources in question, or the existential needs and the right to development of the beleaguered and isolated ethnic Armenian population. Rather, in the words we just saw, it claims that these were, quote, based on the fact that the populations of those areas were Azerbaijani in the past. Perhaps alive to the problem of showing that acts were aimed at people who were allegedly not there to be aimed at, and who Azerbaijan says Armenia was blocking from returning in the future, Azerbaijan also sets great store by its allegations that Armenia mismanaged the water supply from the Sarsang reservoir. Azerbaijan's focus on these allegations is no doubt in part because, unlike the other alleged harms, this is one which, on its case, had effects outside the so-called occupied territories. But it provides yet another example of an allegation where Azerbaijan has provided no evidence at all that the conduct was based on ethnic or national origin. Worse than that, Azerbaijan's own evidence undermines that proposition. The resolution of the Parliamentary Assembly of the Council of Europe, on which Azerbaijan relies heavily, characterizes the alleged mismanagement of the reservoir as a, quote, tool of political influence and a, quote, hostile act by one state towards another. Now, if that resolution is correct in its characterization, which Armenia would of course not accept, then any such action was taken for political purposes, not for a purpose that relates to ethnic discrimination. The next legal hurdle faced by Azerbaijan is the question of whether the acts complained of are capable of having the purpose or effect of nullifying or impairing Azerbaijani's equal enjoyment of human rights and fundamental freedoms. Here again, Azerbaijan's case collapses under the weight of its logical inconsistencies. We can begin by recalling the court's careful analysis in its recent decision in the first Ukraine versus Russia case, which you see on your screens. The court noted that racial discrimination may result from a measure which is neutral on its face, but whose effects show that it is based on a prohibited ground. The court noted that where convincing evidence shows an apparently neutral measure produces a disparate adverse effect on the rights of a protected person or group, then this may amount to racial discrimination unless such an effect can be explained in a way that does not relate to the prohibited ground in Article 1, Paragraph 1. And the court emphasised that mere collateral or secondary effects on persons who are distinguished by one of the prohibited grounds do not, in and of themselves, constitute racial discrimination within the meaning of the Convention. In light of the court's consistent case law on this issue, there are several points which Armenia asks you to bear in mind when considering Azerbaijan's environmental claims alongside the purpose or effect requirement. First, the showing of disparate effects must still be directed at establishing that the conduct complained of was based on a prohibited ground. Second, the showing of a disparate effect will not suffice if there is an objective and reasonable explanation for the disparity that does not relate to the prohibited grounds. And third, mere collateral or secondary effects on a particular group are not enough. As Counsel for Azerbaijan put it last week, in general terms, unless the allegations and evidence relied on show something other than mere collateral or secondary effects, the court should conclude that it lacks jurisdiction ratione materiae over the claims because they are not capable of constituting racial discrimination within the meaning of Article 1.1. As to the issue of discriminatory purpose, we've already noted that Azerbaijan's own case is that the environmental harm it complains of took place during a 3-decade so-called occupation by Armenia of territory which it intended permanently to settle with ethnic Armenians to the exclusion of Azerbaijanis. In these circumstances, it is just as hard for Azerbaijan to show that the alleged harmful acts had a discriminatory purpose as it is to show that those acts were based on ethnic or national origin. And again, we can take the allegations relating to the Sarsang reservoir as an example. Relying solely on inferences, Azerbaijan claims that Armenia's alleged mismanagement of the water supply from the reservoir, assuming that Armenia had any control over it, purposely targeted ethnic Azerbaijanis to suffer from a lack of water. But again, such an inference is contradicted by Azerbaijan's own evidence, along with basic logic. The explanatory memorandum to the 2016 Parliamentary Assembly of the Council of Europe resolution reports that the Sarsang reservoir, located in Nagorno-Karabakh, supplied water to, quote, about 138,000 inhabitants of Nagorno-Karabakh and about 400,000 people in other areas of Lower Karabakh in Azerbaijan. It states that the damage to the reservoir occurred during the war, 1992 to 1994, most likely because of explosives, while fighting took place around the canal. The fact is that after the war, the damage was never repaired. In any event, under these circumstances, water from the Sarsang reservoir cannot be used for irrigation by anyone until the canal has been repaired. So in other words, on Azerbaijan's own evidence, the problems with the water supply from this war-damaged reservoir affected, among others, the entire ethnic Armenian population of Nagorno-Karabakh. In those circumstances, it's logically impossible, we say, for Azerbaijan to show that the purpose of the alleged mismanagement of the reservoir was to disadvantage only ethnic Azerbaijanis living further downstream. This ignores the inconvenient fact that those living in the immediate vicinity of the reservoir, the entire ethnic Armenian population of the area, suffered just as much, if not more. And so the Sarsang Reservoir example illustrates, we suggest, some key flaws in Azerbaijan's attempts to argue that the acts it complains of had any discriminatory purpose. Given this problem, it's not surprising that Azerbaijan falls back on the argument that those harms amount to discrimination because they had a disparate adverse effect. This argument also fails, however, for a number of reasons. Most fundamentally, it fails because Azerbaijan cannot actually show any disparate adverse effect of the acts it complains of. And here we must turn back to Azerbaijan's contorted case on the facts. I've already addressed you on the illogicality of Azerbaijan's attempt to characterize acts as discriminatory, which, on its own case, were done on territory where Azerbaijanis did not live, and to which Armenia allegedly sought to prevent them from returning by military force in violation of multiple provisions of the CERD. In such circumstances, quite obviously, any negative effects of environmental harm in the area fell on the actual residents, the ethnic Armenians. Azerbaijan's attempts to address this logical problem, when Armenia pointed it out, are instructive. It argues that environmental harms were purposely directed at Azerbaijanis and Azerbaijani-populated areas because they were inhabited by persons of Azerbaijani ethnic or national origin, and that regardless of purpose, such harms have had and continue to have a disproportionate effect on Azerbaijanis as a distinct group defined by ethnic or national origin. But it's important, we say, to pay close attention to what is actually meant by Azerbaijanis and Azerbaijani-populated areas. This is a sleight of hand. We've already seen Azerbaijan's claims that the areas in question had been, quote, ethnically cleansed of the Azerbaijani population and remained so during the 30 years of so-called occupation. So Azerbaijan is clinging to the argument that it can found a discrimination claim on the allegation that environmental harm, occurring in various forms across the entire occupied territory, was worse in areas in which a particular group used to live, but no longer did, and to which Armenia allegedly did not intend them to return. Now, the stark question for the court is whether such factual allegations can meaningfully amount to a disparate adverse effect on those absent people, to the extent that this can found a discrimination claim under the CERD. Armenia submits that they cannot, and that to conclude otherwise would amount to an unprecedented departure from the careful and structured analysis which the court has adopted in previous racial discrimination cases. As we saw when we looked at the court's recent analysis in the Ukraine versus Russia case, the showing of a disparate effect will not suffice for these purposes if such an effect can be explained in a way that does not relate to the prohibited grounds. Now, Azerbaijan's position appears to be that at jurisdictional stage, it has free rein to speculate as to the reasons for any disparate effect. But the analysis which Armenia invites the court to carry out in this case does not trespass in any way on the underlying factual allegations. Armenia's case is simply that, as I explained, on Azerbaijan's own factual case, there is no logical basis for finding any differential and adverse impact on ethnic Azerbaijanis. Now, Azerbaijan attempts to advance certain types of rights in support of its claims for environmental harm. In this context, it's worth taking a moment to look at Azerbaijan's arguments on the right to health, as this is, as Armenia says, illustrative of Azerbaijan's flawed approach to the whole of its discrimination claim. Azerbaijan says much about the right to health, but their case really centres on the assertion that the right to health includes the right, quote, to return to a healthy environment, which is crucial to human health. Since this is a third claim, of course, the right to health is not a freestanding right subject to adjudication. Azerbaijan must still show discrimination, meeting all the criteria I've just discussed. And it must show, so far as that discrimination is said to have occurred in the field of the right to health, that that claim properly falls within the scope of that right. But there is evidently nothing in the right to health that includes the right to return to live on particular land in a particular condition. And Azerbaijan's attempts to piece together scraps from cases about indigenous peoples, which it rightly does not claim includes Azerbaijanis, fundamentally miss the mark. The court will recall that last week, Azerbaijan argued that the views of the Third Committee should be disregarded by the court. Despite its professed scepticism about the committee's work, however, Azerbaijan relies heavily on, for example, the committee's decision regarding the Western Shoshone tribe in the United States. This is said to support the argument that an ethnic group has the right to return to an area where it is not currently physically resident. Azerbaijan is plainly wrong about this. The decision makes clear that, despite some encroachments on their lands, the Western Shoshone people have reportedly continued to use and occupy the lands and their natural resources in accordance with their traditional land tenure patterns. In fact, the precise concern, as we see on screen, was that the Western Shoshone people were experiencing, quote, intimidation and harassment by the US authorities in a number of aspects of their life on the territory, as you see listed on screen. And in an even more striking omission, Azerbaijan fails to explain that this case was decided in the context of the rights of indigenous communities, which, the committee noted, possess the right to own, develop, control and use their communal lands, territories and resources. Such rights clearly entail a far broader set of obligations on state parties not to infringe on indigenous land. Azerbaijan rightly does not argue that the ethnic Azerbaijani population that lived in the so-called occupied areas counts as an indigenous community. So the third case law referring to such communities and their very specific rights and needs offers it no assistance, let alone helping to establish the right, as it puts it, to return to a healthy environment. Azerbaijan also attempts to support its case on the right to health with quotes from various third recommendations and concluding observations. Thus, Azerbaijan argues that the right to public health protected under Article 5(e)(4) of the Third encompasses the right to the, quote, highest attainable standard of physical and mental health. But again, Azerbaijan fails to show that this standard includes the right to return to a healthy environment. Indeed, none of the authorities cited by Azerbaijan remotely contemplates such a right. Without a right to return to a healthy environment, Azerbaijan's factual allegations, namely that Armenia's deliberate infliction of environmental harm in, quote, Azerbaijani districts has a, quote, disproportionate and continuing effect on people of Azerbaijani ethnic or national origin who continue to be prevented from exercising their right to return home, end quote, are not capable of falling within the scope of the Third. And Azerbaijan's arguments on the right to property fare no better. All of the authorities cited by Azerbaijan on the right to property refer to the collective land rights of indigenous, tribal or minority peoples living in the relevant region. And again, Azerbaijan rightly refrains from arguing that ethnic Azerbaijanis possess collective rights to land in Nagorno-Karabakh. And Armenia respectfully submits that any contrived claim that the alleged environmental harm violated the right to property should be rejected. In conclusion, Mr. President, members of the Court, Armenia submits that Azerbaijan's claims of discrimination arising out of environmental harm fall outside the scope of the CERD and thus outside the Court's jurisdiction ratione materiae. I have sought to demonstrate the flawed logic which underpins them and the multiple ways in which Azerbaijan seeks to contort the law. Azerbaijan's factual allegations, even if taken as true, are simply not capable of amounting to a coherent claim of discrimination against an ethnic group which was, on its own case, not located in the relevant territory and never intended to return there. Azerbaijan cannot show, firstly, that there was any differential treatment of human beings, secondly, that the harms it alleges were based on ethnic or national origin, or, thirdly, that any such harms had any discriminatory purpose or disparate adverse effect. The whole of Azerbaijan's claims are premised on the illogical idea that those who did not live in the territory at the time suffered more from these alleged widespread environmental harms than those, ethnic Armenians, who did. Armenia respectfully requests the Court to reject these contrived arguments. Mr. President, members of the Court, I thank you for your attention, and I now ask you to call upon Professor Sicilianos.
I thank Ms. MacDonald for her statement. I now invite Professor Linos Alexander Sicilianos to take the floor. You have the floor, sir.
Mr. President, Madam Vice President, members of the Court, it is an honor to appear before the Court today on behalf of the Republic of Armenia. I shall present the last argument in Armenia's first round oral pleadings. This argument is very simple. I will be addressing the reasons why Armenia's preliminary objections can and should be decided in this preliminary objection phase and not deferred for decision alongside the merits. Mr. President, it is undisputed that pursuant to Article 79 ter of the Rules of Court, the Court may declare that a preliminary objection in the circumstances of the case does not possess an exclusively preliminary character and may reserve decision on such an objection for a later phase of the proceedings. Conversely, when an objection does possess an exclusively preliminary character, it has to be decided by the Court in the preliminary objections phase. As the Court explained in military and paramilitary activities in and against Nicaragua, it is quite clear that when objections are exclusively of that character, they will have to be decided upon immediately. This requirement is a result of the amendment of the relevant rule in 1972. The history of this process is eloquently explained by Judges Tomka and Crawford in their separate opinion to the Court's 2019 judgment in certain Iranian assets. In short, under the prior formulation of the rule, the Court had a discretionary power to join the objection to the merits. This unrestricted prerogative to delay decision on objections was being exercised by the Court in a way that prompted criticism. Indeed, one member of the Court wrote that it amounted to an easy way out, which was represented by the neutral and in some cases diplomatic answer of joinder, but which really constituted a postponement of any decision. For example, in the 1964 judgment on preliminary objections in the Barcelona traction case, the Court deferred decision on the applicant's standing to the merits. 6 years later, after substantial further litigation between the parties, the Court finally decided that the applicant indeed lacked standing. It is thus inappropriate for Azerbaijan to invoke that case, which is an example of the undesirable application of the prior formulation of the rule, and, in fact, inspired its amendment. Indeed, following Barcelona traction, recommendations were made in the 6th Committee of General Assembly that the Court should be encouraged to take a decision on preliminary objections as quickly as possible and to refrain from joining them to the merits unless it was strictly essential. This approach was then enshrined in the 1917-2 reformulation of the rule that remains in force today, although it was slightly rephrased in 2019. Accordingly, the Court's power to refrain from deciding a preliminary objection or question is circumscribed to objections or questions that truly cannot be decided in this first phase of the proceedings. To cite the Court's judgment in territorial and maritime dispute Nicaragua versus Colombia, in principle, a party raising preliminary objections is entitled to have these objections answered at the preliminary stage of the proceedings. The only exception is when the Court does not have before it all the necessary facts to decide the question, or ruling on the objection requires a pronouncement on the merits. Objections based on strictly legal questions, which are not intertwined with the merits, are prime examples of the type of objections that should be decided at the preliminary objections stage. Armenia respectfully submits that in this case, the Court should resist the temptation offered by Azerbaijan to defer consideration of Armenians' objections to the merits phase. As I will explain, all preliminary objections of Armenia are of an exclusively preliminary character. I turn now to Armenia's first objection concerning the Court's jurisdiction ratione temporis under the third. Mr. President, members of the Court, it is difficult to think of a more exclusively preliminary question than the question posed by Armenia's first objection. As Mr. Martin explained this morning, Armenia is respectfully requesting that the Court rule on two questions of principle. The first question is whether the critical date for assessing the Court's jurisdiction ratione temporis is 15 September 1996 or 23 July 1993. According to Armenia, Article 22 of the third does not afford the Court jurisdiction over Azerbaijan's claims pertaining to a time when it was not a party to the Convention. The critical date must therefore be 15 September 1996, the date of entry into force of the Convention for Azerbaijan. On Azerbaijan's case, Article 22 does extend the Court's jurisdiction over its claims erga omnes partes to a time when it was not a party to the Convention. According to Azerbaijan, the critical date would thus be 23 July 1993, which is the date of entry into force of the Convention for Armenia. Deciding this question simply requires the Court to undertake an exercise of treaty interpretation in light of the relevant principles of international law. There is no need to assess any factual evidence or trespass on the merits in any way. As explained by Mr. Martin, Armenia is not asking the Court to assess whether each and every one of Azerbaijan's allegations fall within or outside the Court's jurisdiction. Instead, Armenia is asking the Court to provide a pronouncement of principle that will allow the parties to know where they stand and to plead their cases on the merits efficiently and effectively. This means formulating their allegations, defences and analysis of the evidence in light of the applicable critical date. If the parties are required to present alternative cases on the merits, depending on which critical date applies, it will create unnecessary confusion and inefficiencies. The same considerations apply equally to the second question that Mr. Martin addressed, which concerned whether Azerbaijan's claim on ethnic cleansing falls within the Court's jurisdiction, even if the critical date is set in 1996. Here, too, the Court need not get into the facts, other than to know their absence. As Mr. Martin explained, Azerbaijan does not allege that any populations were displaced after 1994, and its theory of composite breaches cannot extend the court's jurisdiction to cover facts or events that occur before the critical date. Azerbaijan invokes in this context the Croatia versus Serbia genocide case, arguing that it sets a precedent for the court to join to the merits a preliminary objection concerning acts on violence spanning the critical date. There is, however, a drastic difference between that case and the present one. In Croatia versus Serbia, an armed conflict straddled the critical date, which fell in the middle of Croatia's allegation of a, quote, a pattern of conduct increasing in intensity throughout the course of 1991. In contrast, in the present case, the critical date falls more than 2 years after the cessation of hostilities and the conclusion of a ceasefire agreement. The considerations of admissibility addressed by Professor Darjean, whether concerning judicial propriety or extinctive prescription, are also exclusively preliminary. They concern purely legal questions that, by their very nature, have to be addressed in this preliminary stage. Mr. President, members of the court, ruling on Armenia's first and second objection is not just a matter of efficiency, but also a question of fundamental fairness. Defining the temporal scope of Azerbaijan's claims at this stage will allow Armenia to determine whether or not to bring counterclaims in its counter-memorial. As is well established in the court's jurisprudence, counterclaims must be sufficiently connected to the principal claim and must form part of the same factual complex. This includes a requirement that the relevant facts occurred during the same period of time. In formulating counterclaims, it is critical for Armenia to know the permissible temporal scope of the court's jurisdiction over Azerbaijan's claims. This brings me to Armenia's objections concerning the court's jurisdiction ratione materiae. Mr. President, members of the court, Armenia's objections ratione materiae also possess an exclusively preliminary character and should be resolved in the present phase of the proceedings. I will explain why this is the case with regard to both Azerbaijan's claims pertaining to landmines and to the environment. First, as Mr. Salonidis explained, Azerbaijan's claims pertaining to landmines and booby traps can be disposed of very easily. The court has rejected all of Azerbaijan's corresponding requests for provisional measures, finding that the rights invoked by Azerbaijan were simply not plausible. Despite Azerbaijan's attempts to reformulate its case at the last minute, the court should regard its claims as remaining the same as they have been all along. The court has all the necessary elements before it to decide Armenia's objection as it relates to landmines and booby traps. All the